I share your concerns, Ron, about how serious this may be, but what bothers me about where we are in this point in the process is that we don't have an application. And what really bothers me about doing a moratorium right now is that if the application comes in and we see, oh my goodness, here's a big hole in our ordinance, what are we going to do about it? It's too late. We will have shot our wad. I think it's premature to do a moratorium at this point.
I don't understand. Let's say somebody does apply for a mining operation like this. You're saying that we would then do a moratorium to study it?
No, we would apply our ordinance. If we find issues with our ordinance, then we would deny it and declare an opportunity and declare a moratorium and say, look, we need to look into this, whatever it is that we hadn't thought about that is not covered in our ordinance.
But we can't say that our ordinance can't address them. And I guess I can't support a moratorium until we can come in and say our ordinance cannot address these concerns and these fears. The fears are legitimate, possibly. We'd have to look at the evidence. But we can address them under ordinance. We can't say we don't have an ordinance to address this. We do.
All we're doing is guessing. There is no permit in here. We don't know what they're going to do, or how they're going to do it, any way or form.
The letter, or I took that based on it. We all got 620, a letter of intent, just information from Windsor. The first sentence just says they purchased 3 parcels in Meade County with the intent of extracting sand and gravel. And this ordinance is so difficult to get through. Only a company with a lot of dollars really can succeed in doing it. And even the 2 that have gone through, I'm not sure about the one. I know one never opened because of costs that were involved in material. So this is a very difficult ordinance to get through. I know personally I've been through it, and it's a challenge to get through this. It has a lot of stuff in there. It is a very difficult ordinance for any company to use over time. It's not a cakewalk.
County attorney is here, and would you like to talk a little bit about the process that we went through to do the update on the ordinance?
I did work on the drafting of the ordinance that people have been discussing, and I appreciate the confidence that's been expressed in that. It was. Having said that, there's a couple of things I want to point out. It was a very definite attempt at the time to address the issues that we were seeing. We were dealing mainly with issues of nuisance concern. The hours of operation, dust, noise, those were all dealt with largely from a standpoint of, is this something that bothers the neighbors? Okay, so when we put in 600 feet as a distance in there, that wasn't a health concern. That was a statement to the people who wanted to develop the resource that this is what we're going to be looking at to protect the person who wanted to run the operation, who could say, I know what I'm responsible for is something I can actually control. So we had a number of these kinds of things that were in there to protect the utilization of the resource, and other things that were in there specifically to protect the neighbors. Most of these things, I think, are really viewing the product that we're mining as an inert material. We're not talking about a health risk from aggregate in general. So that was not a consideration in any of our discussions. We didn't say, will you get silicosis if you breathe the dust from this mining operation? That wasn't a discussion that was had. So that's a different area that hasn't been covered in developing this ordinance. Now, I think it's safe to assume, as Mike has described, this resource exists in a layer across much of the, well, at least the eastern half of the county. Having just been to the Public Utilities Commission to discuss wind, they were very supportive of the ordinance that that you folks helped craft and that the county board ultimately adopted. The one complaint they had was it came very late in the process for this applicant because the wind company had applied before the county ordinance was even under contemplation. And subsequently, the wind ordinance was adopted, but it was adopted, you know, very late in the company's planning process. So some of the commissioners expressed concerns it wasn't fair to that applicant. So it might be that getting the ordinance out there first, having the public discussions, having people get their questions answered would be more convincing if this is tested in court. But we have a lot of existing operations that were there before we adopted this ordinance and have been allowed to continue because we don't have a right to go back and restrict what they're doing.
And they came in and we have a concern about health, like air quality or water quality. And we would tell the applicant we cannot go on with this application until you provide us with a report from the PCA that says it's safe. And they say, no, we gave signed a 60-day rule. You need to rule on us. And so we say, sorry, not enough information. We say, no. Is that enforceable if we say no because they refuse to cooperate and provide the information that they asked for?
Your remedy when you don't have enough information that you think is necessary is to, within that 60 days, deny that permit because you don't have the information you think is necessary to grant it because they haven't established the factual basis that would support the permission you're granting. Then their remedy is to challenge that. And they could go to court and they could say to the court, well, these folks are no experts and we have provided all the information that a reasonable group would want to request, and therefore, Judge, you be the reasonable person in the room and, you know, tell them that they're being arbitrary and capricious and that they are not really setting an acceptable standard and that my rights are being infringed by that. So if we pick something that other groups have criteria on, and we say, well, that's not good enough for us, and they say, well, we've given you everything that every other group requires, then are we really in an appropriate place saying no? On the other hand, if we're saying, give us the things that every other group requires, and they're saying, you know, we don't have to do that, then we're probably well within our rights to say you haven't met the minimum standard.